Okay, Devdan.
Should I start?
Yes, please.
Yes. I'm Temten Dalal, Chairman, World Zoroastrian Chamber of Commerce, Mumbai chapter. Welcoming all the viewers today, members as well as non-members. And a very big request to non-members to become members of the World Zoroastrian Chamber of Commerce. It is a wonderful organization. The young entrepreneurs are there, and we are also giving loans at no interest. And hence, I request all those who are not members of WZCC to please become members of WZCC. It is a humble request because if we all Parsis join together, we can certainly make a very big impression on the WZCC. Today's webinar is on Manek Kalyaniwalla, a wonderful speaker and an outstanding man in the field of wills, codicils, cooperative societies. He is very well versed in that subject. And I'm sure today the audience is going to get full value for the view that they are going to have and the advice that he is going to give. With these words, I now request Parsi to please introduce the keynote speaker of today's evening. Thank you.
Thank you, Duncan. A very big hello to all our viewers. Through popular demand, WZCC Mumbai chapter presents to you for the third time Mr. Manek J. Kalyaniwalla. On Friday, 28th March 2014, WZCC Mumbai chapter had arranged a workshop on Parsi Succession Act of 1865, which was held at the Ripon Club, Mumbai. This was a very interesting interactive workshop pertaining to the Parsi law, which is applicable to Parsis as regards succession, inheritance, marriage, and divorce. On Saturday, 11th April 2015, WZCC Mumbai chapter had arranged another workshop on Indian Succession Act of 1925 as applicable to Parsis held at the Bombay YMCA Central Branch. Both the above workshops were attended with great enthusiasm. There were suggestions to revisit such a session once again. This time, as the talk is through a webinar platform, we are sure it will reach and benefit a larger audience. Manek J. Kalyaniwalla, advocate and solicitor, principally practicing at the Bombay High Court, has been serving his profession with exemplary honesty and dedication for the past several years. With his impeccable reputation and wisdom spanning over 25 years, he also has the cause of the community close to his heart. Acknowledged as an expert in personnel, estate, trust, allied civil laws, and civil litigation, he is seen both as a guide and an advisor to his clients and a mentor to the younger generation who are opting to choose law as a profession. Born in Bombay, now Mumbai, he is the first generation advocate and solicitor in his family. Being awarded the Ashburn Scholarship from his alma mater, the prestigious Government Law College, he had the good fortune of being signed on as an articled clerk and thereafter as a solicitor assistant of Dr. Edward B.H. Antia, senior partner Mullah & Mullah and Craig Blunt and Carroll, where he owned his talents and gained valuable experience under the watchful eye of Dr. Antia. Manek has also assisted various senior counsels in high-profile cases right up to the Supreme Court of India and has successfully carried out trials and conducted final hearing of cases as an arguing counsel. Manek has a dual qualification of being a solicitor in the UK, and his name appears on the rolls of solicitors of Supreme Court of England and Wales. Manek is also a trustee with various charitable trusts, which opposes the cause of the poor, needy, and the indignant people. Recently, he has been elected unopposed as the director of the Zoroastrian Cooperative Bank Limited. Manek is a history buff, very fond of fine arts, passionate about athletics and an avid scouter with the 16th East Zoroastrian Bharat Scout Group. Manek thanks Ahura Mazda for having the opportunity to be mentored by Dr. Edward B. Hench Antia. He thanks past president of WZCC and ex-chairman of BPP, Mr. Meenu R. Shroff, and is grateful for the unstinted support of Mrs. Meher Kersi Besania, Chair Dubai Chapter, Mr. Kharas, Mr. Adisagan Poria, Mr. Aspi Antia, and last but not the least, his very supportive parents, Jangu and Khurshid. And now, with this brief introduction, we pass the screen over to Mr. Manek Kalyaniwalla to appraise us on today's topics, Rudiments of Will Making, with emphasis on Parsi Zoroastrian laws. Thank you. Over to you, Manek.
Thank you very much for your kind words. A very good evening to all my listeners, to my respected seniors who I see are on the screen, my fellows from my fraternity. A good afternoon to my listeners in UK. Mr. Havli is there. A good morning to Ms. Taliyar Khan, who has joined in from America. It's 5 a.m. over there. Thank you so much. And salutations to all of you. And if we can have the first slide, I will just briefly go in because I know that we have a time constraint over here. So if we can start the screen sharing. Now, the question of wills is as old as the Romans. I mean, the first way where we see the wills have been done was from Julius Caesar. And from his time, there has been a will and how the wills have been evolved over ages. Now, the topic of wills is a topic which is not very well taken in by the audiences or by the clients because they associate it with death. I know that it is not a glamorous topic like mergers and acquisitions and has always been brushed under the carpet. But when the succession kicks in, that is when a will reigns supreme. That is when it is felt by the successors, by the heirs, that had the deceased person made a will, things would have been much, much simpler. So with this brief introduction, let me just give you how the wills have evolved or how the testamentary law has evolved in our country. Now, as you know, that India was ruled over by the Britishers. So basically, the British common law up till 1835, the law of primogeniture was applied. So the English common law was applied to the Parsis. But thereafter, to cut the long story short, the Parsis had their own place in the sun. And knowing that what all had transpired and what all case laws were filed, they thought it fit to apply to the legislature to have their own set of laws which could be put into practice. And thus, the way of wills or the Parsi Succession Act started coming into play. Now, today, as the law stands, the Parsi Succession Act, or I should not say the Parsi Succession Act, the succession relating to Parsis is now codified into the Indian Succession Act of 1925. Now, principally, I will just be touching upon the law which relates to the Indian Succession Act because we are having a little global audience. So I will not be going into citing the sections and the case laws and all those things, but I will be giving a brief overview of what are the rudiments of will making because it has a global impact and mostly the laws or the basic framework is the same. So I will be touching upon the aspects of how to make a will, what are the points to be borne in mind, what property can be bequeathed, what property cannot be bequeathed. And thereafter, I will also dwell on the latest developments which has taken place after 2014-2015. Because the last workshops which we had were in the year 2014-2015. Okay. So now let us just dive into the topic of what is a will. Now, if you see on the screen, I have broken up the definition of a will. So what is a will? The first thing, it is a legal declaration. Then if you break it up, legal declaration of whom? Of a person. But of what of a person? It is of the intention of a person. Okay, so it is a legal declaration of the intention of a person. What does it relate to? It relates to his property. Very well. If it relates to his property, at what point in time should it relate to its property? During his lifetime or during his death? So it relates to his property, which he desires to be carried into effect after his demise. If anything happens before in or during his lifetime, it is called as a transfer. Otherwise, after his demise, whatever he wants to do, he can make a will, so that it is a legal declaration of his intention with respect to his property, which he desires to be carried into effect after his demise. Now, a legal declaration means what? It means that he has to write it down, okay, of his intentions. So a will is basically an ambulatory document, meaning that it takes effect after the death of a person, and whatever are his desires during his lifetime, which he wishes to carry on after his death, it is a speaking document to that effect. Okay, now with this, let's go to the next slide. Okay, now what do you mean by a codicil? Now, I have this down and made it simpler for the viewers to understand that a codicil means a document made in relation to a will, which explains, okay, orders or adds to the dispositions of the will and shall be deemed to form a part of the will. So you can say, okay, we do have a will. Now, why do we need a codicil? So a codicil is like an addition to the document, to the main will, which explains. So if the will is little ambiguous, then the testator can say, okay, I want to explain a little bit more, or I want to add something, I want to delete something. And this document, which is called as a codicil, will form a part of the will. Okay, so this is what is meant by a codicil. You don't have to make a fresh will for every little mistake which you make, which you want to clarify. You don't have to make a new will. You can always get it done by way of a codicil. Now let us see the familiar terms or the jargon which is used. Okay, so the next thing is, who is a testator? We always hear testator, testator. Okay, so a male who makes a will is described as a testator, and a female is known as the testatrix. Okay, that is a very simple thing. So the person who makes a will is a testator because that is his testimonial. That is why the testator. And a testimonial of a female person who makes the will is a testatrix. Now let's go to the other thing. Now any person dying, leaving behind a will, dying without leaving behind a will is known as an intestate. If you die leaving a will, you are known as a testate. If you die without a will, you are known as an intestate. Then the normal terms which we come across, who is an executor? So an executor is a person in whom the testator reposes confidence to execute his wishes, and such person is named in the last will to carry out the directions and wishes of the testator. So he is known as an executor. So simply put, a person who enjoys confidence of the testator or the testatrix, he is given the responsibility, he is given the onerous task, he is given the duty to put into effect the wishes of the testator upon his demise. Now, we always hear, what is the probate? What is the probate? So everybody understands loosely what is the probate. But for the purposes of the audience and for the purposes of the seminar, what do we mean by a probate which is there? A probate means a copy of the will certified under the seal of the court, granting administration to the estate of the deceased to the executor named under the will. So what is a probate? It is basically an executor making an application to the court saying that, look, honorable court, I am the executor. This is the will of the deceased. Please give me your approval so that I can carry on my duties as an executor and carry out the wishes of the testator. Now, who is an administrator? An administrator means a person who is appointed by the court to administer the estate of the deceased, and is usually appointed where there are no executors appointed under the will, or if an executor refuses to act as an executor or there is no will. Now, the difference between an executor and an administrator is very, very different. We have to understand it. Now, an executor is a person who himself goes to the court and says that, look, honorable court, please, I am the executor appointed and I want to carry out the wishes. So kindly grant me your permission, kindly certify the will as a genuine so that I can carry out the wishes. So that is an executor who applies for a probate. Now, an administrator means the court is appointing a third person. There is no executor appointed under the will. That is one case or one scenario. The second scenario is where the executor is refusing to act under the will and the heirs to the will or the legatees are saying, "Arey, look, the executor is not doing. Are our rights going to be hindered? Are our legacies not going to be given to us?" In such a case, an application is made to the court and the court will appoint an administrator. So that is the difference between an administrator. Now let's see what do you mean by a succession certificate? Now, a succession certificate is basically granted. I'm just reading it, then I will explain it to you in a little more detail. That a succession certificate is basically granted in respect of any debt or a movable property like a bond, money, stock of companies, bank accounts, whereby the heir goes to the court and says that, look, I require a succession certificate in respect of a debt or a security. So you can apply for a succession certificate only if the testator has properties like a PPF account or a bank account or stocks of company. So these are all movable assets. So if you go to see that in a will, you may have properties which are movable or immovable. Okay, so in a movable or an immovable properties are there, then either you require a probate or you have to go in for a letters of administration where there is no will or where a need of an administrator is there. And a succession certificate is completely different from the above, where you just have to go to a court and say that, look, I am the successor to the estate of so and so, and basically the estate consists of movable properties, hence I need a succession certificate. So generally, if you go to any bank or a company or a PPF account or any other thing, you know, the standard reply everybody will get is that please obtain probate or a succession certificate or a letters of administration. In short, get an order from the court. Okay, now having explained all these things, now because these are all the rudimentary definitions or the concepts which y'all as an audience must know. And now, who is an heir? So let's see who is an heir. Now, is an heir a legatee? Is a legatee an heir? So now I want to clear those things, clear these concepts, and who is an heir? So let's see. An heir is a person whose lineage can be traced in relation to the testator. It can be ascending or descending order. That means like a father, or that is the ascending order, or a descending order. That means the son, grandson, great grandson, or in close kindred. Kindred would mean your siblings and all, your brothers, your sisters, your brother's children, your sister's children, like that. Okay, so now after knowing the concept of an heir, so heir is basically you can trace a bloodline. So that is an heir. Now, who is a legatee? Okay. Now, can we have a Now, a legatee is a person or an entity or a company or anybody who derives a benefit under a will. Okay, a legatee need not be an heir. He can be a universal legatee. Now, in so far as Parsis are concerned, they are free to give or bequeath their property to whomsoever they like, to the even to the exclusion of the heirs. So you have to get the concept very, very clear as to who is the heir, who is the legatee. So I hope that it is clear. I'm just repeating it once more in a very, very quick nutshell, that a will is like a declaration which is made of an intention. It should be in writing of his property. A codicil is like a document where you make few additions, corrections, alterations. You don't have to make a new will. A male person who makes a will is a testator. The female is a testatrix. A person who dies with a will is a testate. A person who dies without a will is an intestate. A person who is named in the will is an executor. If there is no will, or if there is a will which has no executor named, any person who has got an interest in the estate can go to the court, apply himself, herself, or themselves to be appointed as administrators. Succession certificate is only for the limited purpose of succeeding to movable assets like bonds, annuities, shares in a company, demat accounts, bank accounts, PPF, or any other notified security. An heir is a person whose lineage can be traced to the relation to the bloodline can be traced in relation to the testator. It can be father, son, grandson, so on and so forth, and even brothers and sisters, brothers' children and sisters' children too. And a legatee need not be an heir. He is a person, entity, a group of person, an association like WZCC who can be as a legatee if somebody wants to give a part of their estate to them for the purposes of, meeting their objectives. Okay, so let's go to the next slide now. So with these important concepts, now we'll go to the next slide. Okay, now normally a question is asked, is making a will necessary? Because as I told you, that people have this concept in mind that if we make a will, I mean, we have reached the end of a lifetime. So, and it is a sort of a morbid situation because everybody loves their own life. So they will procrastinate and keep, making a will till the end of their life, or in some unfortunate cases, something bad happens and they don't make a will. So is making a will necessary? And if so, is a probate necessary? Now, these are the normally questions people all over the world, Indians all over the world, Parsis all over the world, they ask. Ke jarur hai ke nathi jarur? So let us see, when a person makes a will, what does he do? Basically, he regulates succession of the properties which he desires to effect after his demise. Now, this is known as a testamentary succession. Suppose if he dies without a will, then he dies, as I told you, he dies as an intestate, and the non-testamentary succession comes into play. And the personal law to which he is subject to will be applicable. So the Indian Succession Act, now coming and linking it to the Indian Succession Act, it envisages 2 points or 2 broad heads. The first broad head is you make a will, you give your property to whomsoever you like. And I'm only talking this in relation to Parsis. Because in Muslims, you can only bequeath a part of the property. In Hindus, they have their own rules. Because you see, in India, being a cradle of world religions, we do not have a uniform civil code in place. So every community is bound by their own personal laws. The Christians have their own personal laws. The Hindus have their own personal laws. The Muslims have their Sharia. The Buddhists have their own laws. And all these laws are encapsulated in a major act, which is the Indian Succession Act. Please note the words Indian Succession Act 1925, which is applicable across the board. And this act takes care of each and every religion in India. It takes care of the Hindus, it takes care of the Christians, it takes care of the Sikhs, the Buddhists, the Jains, and the Parsis. It does take care of the Mohammedans also to a certain limit, but it does. So the law states that you choose, it's your choice. You either make a will by which you yourself, the power to give your property, it's in your hands, and which is known as a testamentary succession. And if you do not choose to make a will, fair enough, you may die as an intestate, and then the law, provisions of law relating to intestate Parsis, which we are coming later, will kick in. So as you see, the rules of intestacy as applicable to the Parsis will apply. In other countries, because we do not have a we do not have, or they do have a uniform civil code over there, such distinction is not, or such, what you can say, benefit is not given to the Parsis living all abroad, all across the world. They are given this recognition in India. Now, a well-written and a valid will. Please see the words a well-written and valid will. I will come to what is the valid will later. Smoothens the transmission of an estate. Please see the word transmission. If a person gives property during his lifetime, it is known as a transfer between two living persons. It is called inter vivo, Latin words. And after the death, it's called as a transmission. So a well-written and a well-written and a valid will smoothens transmission of an estate to its rightful legatees. It avoids a lot of heartaches and headaches for the family. And experience shows that in absence of a will, there are instances of family feuds erupting. Why family feuds erupting? Because in the absence of a will, the laws relating to intestacy will start applying. So even if you have bad blood between your cousins and all, they can always claim a right in the property of the deceased. So let us see, further experience shows that what happens is the heirs themselves are not aware of what properties the testator has died of, and which results into usurpation of properties by a third parties. Now let me cite some very frightening examples. In Jame Jamshed and in Parsi Times, you will see that there are certain notifications which are coming whereby a citation is printed in Gujarati that so-and-so person has applied for a probate or a letters of administration of a Parsi who died intestate or who died testate. And these people are completely, if you read the names, they're completely third persons or third parties. So you see what happens is that others take advantage of usurping the property in case there is no will, or in case there is a will but there is no executor. Okay, so can we go to the next slide, please? Okay, so the question which follows is making a will necessary? And in the present times, if you see that because of all these things where there are, people dying without a will, the government authorities, the non-government authorities, the banks, your housing societies, your local bodies like your municipalities, they will always ask for a probate, or they will ask you to produce a letters of administration or a succession certificate from a person who is claiming. So if you go and say that and tell any local body or say that, look, my ex had a property, it is an immovable property in a prime location and I am the heir. So why don't you transfer the property in my name? The government or the local authority will say, yes, surely, sir, we will do it for you. But please obtain an order from the court by way of a probate or a succession certificate or a letters of administration, and then we shall do the needful. So looking into all these factors which I have narrated above, it is strongly urged to have a will in place. It is strongly urged to have a will in place. The nitty-gritty of preparing a will always lies with a legal professional, and it is further urged that you seek an appropriate guidance from a legal professional in making a will. So, having said this, now let us see that when a probate is granted, when you have a will in place and when the probate is granted, the genuineness of the will is certified by the Honorable Court under its seal, and it is binding on the world at large. This is very, very important. It is binding on the world at large. And the right of an administrator or an executor can only be established only when the will is probated or the letters of administration are granted by a competent court. Now, for Parsis who are residing in Bombay, Madras, and Calcutta, it is mandated by law. So there is a section which says that look, if you are a Parsi who has expired or who has demised in the jurisdiction of, or within, it is called as an ordinary original civil jurisdiction of Bombay, Madras, and Calcutta, you compulsorily need to get your will probated. Without probating your will, your executor will not have the right to carry out the wishes before the world at large. So to have his right established, the law says that you must get a will probated. There are no two ways about it. And if a Parsi owns property, immovable property, beyond the jurisdictions of Bombay, Madras, and Calcutta, so in respect of those immovable properties, a probate is compulsory. So if a Parsi dies in Pune, or if a Parsi dies somewhere in Jamshedpur, and he owns immovable property in Jamshedpur or Pune, then for that immovable property, you must have a probate. You have to go to the court and you must get a probate, without which your rights cannot be established, without which you cannot proceed further. So, stating this, yes, if you ask me as a legal professional, is making a will necessary? I would say yes. Though I have said it is strongly urged, I would say yes, making a will is necessary. Now, when should you make a will? Is there a time limit? Now, that entirely depends upon the person who wants to make a will. You can make it now, you can make it after 2 years. If you say that, okay, look, I have enough property in hand and I would like to do it right away, so I can do it now, and thereafter a few years revisit my will and make corrections, you can do that. So yes, you need to have a will in place. It will surely avoid heartaches and headaches for your family. And there is one Gujarati saying which I will like to say, which says Lakhanu te vanchano. Lakhanu te vanchano. What is the written word? Reigns supreme. No oral words. Whatever you read will reign supreme. So this is the Gujarati saying which I have learned from my seniors. So when a will is there, you can say it that look, the person has signed the will and these are his wishes, and this is what he has desired the executor should do. Okay, so now having said this, now let us go to the next slide of what are the points which are required to be borne in mind when making a will. Okay, so whenever a client comes to us and asks us, sir, what do we need to do it? What are the points we should bear in mind? So the points I have just briefly indicated. Now this is basically in a nutshell which I have given so that all our viewers can understand it. So what you can bequeath is only what you own or will own. So you cannot bequeath something which you do not own. So what is your ownership? Your lawyer will be able to tell you. Now, many a times people will come up to us and say, okay, look, sir, we are a tenant of a property and the landlord is Mr. X. Now, can I bequeath my tenancy to my children or to my cousins or to anybody of my choice? Now, the law is very clear on this. I'm talking about the Indian law. Now, the Indian law is very clear on this, that if you have a tenanted property of, you cannot bequeath that tenancy because you do not own it. So if you do not own it, how are you supposed to bequeath it? Your property is the owner of is the landlord. So you cannot do that. Or if you can say that, or you are going to purchase a property of your own merit in a society, and you have a feeling that no, I will be purchasing a property maybe after 2 years, but let me make a provision of it right now because 2 years is quite far off. But and buying the property will take a couple of 2 years because of this pandemic, holidays, or whatever reason. So if you are in the throes of making or purchasing any property and you also want to make a will by the side, so you can say that, look, I am in the negotiations with so and so party and I'm going to purchase this property and I have already made part payment. Now, if something happens to me before the sale is concluded or before the purchase is concluded, then my executor will have a right to conclude the sale or the transaction. And once that property comes to my estate, then that property should go to ABC, EFG, or whatever. So you can only bequeath what you own or will own. Now, a person who desires to make a will must be clear in his mind what his executors are supposed to do, right from beginning with the disposal of his mortal remains. And for the purposes of carrying out funeral ceremonies or whatever, I mean, everybody has their own mind. Everybody, I mean, we get requests, look, sir, I want to be either consigned to the Dokhmanishi or I want my body to be cremated. I have some clients who come to me and say, I want my body to be given for scientific purposes to a medical college. So your executors have to know of this. I mean, what they are supposed to do, because upon the death of a person, the executors stand vested of the estate from the date of the death. So then they become the karta dhartas or the whole and soul persons on whom the onus is there to carry out the wishes. So thereafter, carrying out the disposal of the mortal remains, thereafter carrying out the funeral expense, the funeral ceremonies, the obsequial ceremonies. Now, Parsis have this of the first 4 days, the 10th day, the first month, the 6th month, then the yearly prayers, the muktad, the vandidad. So all that has to be provided for. Some Parsis say we want only ABCD prayers to be done. So the executor has to know of it. Like, okay, this is his intention. So, and so they are aware and they are clear in their mind. Thereafter, payment of debts. If you owe some money, either you owe money by way of unpaid taxes to the state exchequer. So all those things you have to, or if he has taken a loan from somebody and he wants to repay that loan. So the executor should know that what are the debts of the deceased person. And the third thing what you have to see is that after payment of the debts, what are the estates remaining, which are open for division, So everything has to be charted out. Everything has to be carefully thought over. Making a will is not an overnight job. It cannot be said that please make a will of 2 pages or please make a will of 3 pages. No, it doesn't go that way. You really have to give it a deep, deep, deep thought, because as I said it, whatever you own, you can only bequeath, or whatever you will own, you can only bequeath. Then again, coming to this, that what are the duties of the executor, that has to be done. A will is one of the most solemn documents known to law. A will is one of the most solemn documents known to law, and the courts always will give it a little more care, a little more patience, a little more what you can say, a little more time in understanding like what the executor wanted. The court will have its own process in certifying the genuineness of the will, but because the probate court is a court of conscience, so a clear and an ambiguous will is a boon for the executors and the courts alike, for they are very clear about the wishes and the intentions of the testator. So I would urge you all to keep these points in mind. Not go to your legal professional and say, to curtail my cost, please make a will of 2 pages. I don't want to make a will of more than 2 pages. It does not happen, because then it will just land up in a haphazard and a not a professional job. A legal professional can be of great help when a roadmap for a will is desired to be drawn up, because he has that experience, or he has the foresight with his experience to look into the future and see that what situations can crop up at the time of administration of the estate. And this experience comes in very, very handy when a legal professional is guiding his client. So I would urge, I mean, please go to a legal professional. I mean, if you want to write a will in your own hand, you can do so, but take the help of a legal professional. For example, if you have a headache or a bad headache which is not going for days, you will not self-medicate. You will always go to a doctor. So keeping that same analogy in mind, you must visit a legal professional who will guide you, because you see there are different types of property. You may hold a property jointly, you may hold a property as a co-owner. It may be a tenanted property, it may be a leasehold property, it may be a freehold property, it can be an inami property. You see, all these things law has taken care of. Now, a lay person will not understand these nitty-gritties of a joint ownership, a co-ownership, which a legal person with his experience and with his training and with his education will be able to guide you. So rather than, properties just being frittered away wantonly like that, it is suggested that you go to a legal professional and who will guide you in so far as what type of properties you have. He will sit with you and he will take down your history as to, okay, what properties did you have, how has the property devolved on you, you know so immovable property can be bequeathed under a will. However, it has to be exercised that joint property cannot be bequeathed. So if you tell a legal professional, I have a joint property, he will hear you, but then he will ask you, okay, please show me a document whereby are you holding a property jointly, or in reality you are holding a property as a co-owner. Now I have got queries which says that I am holding a joint property with my husband, and in the brackets it is written co-ownership. So when a person is not fully aware of the facts as to the way they hold the property, you know, either jointly, freehold, as a tenant, it is best to approach a legal advisor. I'm not saying any other person, but a legal advisor or a legal professional who is a trained person to guide you for this. Now, movable assets can also be bequeathed under a will, so there is no problem with that. Okay, now let's go to the next slide. Okay, now you see what other points you can bear it in mind is that you can create a trust under a will. If you are a person of means, you can always create a trust. You can create a private trust whereby you can tell your executors that you will look after the minor child of mine till he touches 18 years of age or till he reaches 25 years of age, which is a private trust. And you can also provide that you can have a public charitable trust which is registered with the charity commissioner. So this, all your intentions, whatever is the deepest desire of your mind, you have to be clear in it. You have to put it on paper. You have to approach your legal professional, and he, after studying everything, will be able to guide you. Now, Parsi, thy name is charity. Now, this adage is known to all, but nowadays it's practiced by few. To ensure the continuance of a family name or a memory, grants can be given to various institutions for enhancement of a charitable, a social objects of or a social object. I mean, the Parsis of yore always used to give a part of their estate for the betterment of a community as a whole, and it was also given to for the betterment of indigent Parsis and for instituting grants for studies, further studies, relief from property, medical, medical. It was given for building of schools, building of tenements, the fruits of which are enjoyed by the present generation. I mean, there are various institutions which the community requires support. And if you want your legacy, if you want an enduring legacy, and you want to leave a footprint on the sands of time, you can always do a little bit of charity. Now, let me draw a parallel to the Muslim community over here. Now, in the Muslims, you compulsorily have to give 10% of your property for charity under the Sharia. You know, then there are no two ways about it. So it is mandated by their personal laws. So in coming, I mean, though it is not mandated in the personal laws of the Parsis, but still, I mean, our Sethias and our Akabars, they've always given or donated large sums of money or a part of their properties for the community objective. So, and the community, and today we have seen like community institutions have basically benefited, and they in turn pass the benefit to the Parsis, to the other Parsis. So so this is my personal view that if you want, you can always give a part of your legacy for any purpose, including a charitable purpose. Okay. So since the will is like a morbid thing, you know, associated with death, if I make a will, I may die late, soon enough, or within a month or two, I'll die. No, it's not that. Don't worry. A will is an ambulatory document. I mean, you are free to make your will as many times as you want. You're free to alter it as many as times you want. You can even revoke your will. It is not that once you have made your will, you are bound by. No, you can keep on altering your will. You can even revoke your will as many as times as you want during your lifetime. Okay, so the will, as we say, is an ambulatory document. You can keep on doing it. Now, who can make a will? Now let's see who can make a will and what are the legal requirements. So now you have made up your mind that, okay, Mr. Kalyaniwalla has impressed upon us, we must make a will. So we are now clear in our mind that we want our estate to be disposed of in a particular way. We want to die testate. We don't want to die intestate. So now who can make a will and what are the legal requirements? Now, simply put, every person of sound and disposing state of mind. Now, these are the very words which are used by the law. And not being a minor may dispose of his property by a will. So if you see in the bracket, I have put unprivileged will. Okay. So now you'll be wondering why is an unprivileged will and what is a privileged will? Just if we read the slide below with the differentiation will be very, very clear. So every person of sound mind and disposing state of mind. Disposing means he's aware of what he wants to do. He's aware of the time and space around him. He is aware of how his legacy has to be effected. A person may be bound in a wheelchair. For example, if I may, with respect, quote a person like Dr. Stephen Hawking. I mean, he had a sound and disposing state of mind, but his body wasn't. Now, can a person like Dr. Stephen Hawking make a will? The answer is yes, he can make a will. Why? Because he is not a minor. Minor means a person below the age of 18 years, and which is now universally accepted. But he was a person of sound mind and a disposing state of mind. So his will, if he makes a testament, which is his will, that will be a valid will. You may not be in the best of physical state, but what the law mandates and what the law requires is that you must be a person of sound and disposing state of mind. Now, every person can make a will, and these wills are known as unprivileged wills. Now, what are is what are the privileged wills. Now we have frontline, now we have our armies. Now there are special rules for preparation and execution of wills by soldiers, sailors, and airmen. Now we Parsis have been in the armed forces. We Parsis are still there in the armed forces all over the world. Now for them, the law all over the world has mandated special rules. Now they are the privileged people because they are in active service. They are either on an expedition, they are either flying in the skies, or they are on a mariner, they are on a marine expedition. So a soldier, a sailor, and airman, they are the persons who can make what is called as a privileged will. Now, there are people who are specially abled also. Now, can a blind person make a will? Can a dumb person make a will? Or, if they are majors, can they make a will? The answer is yes. A blind person, a dumb person, a specially abled individual can also make a will, provided they know what they are doing, what they are disposing of, or what they are doing. So giving the example of Dr. Stephen Hawking. Now, Dr. Stephen Hawking was a specially abled individual, very, very intellectual. He can make a disposition. For example, uh, can a blind person make a will? Yes, a blind person can make a will, provided he knows what are his assets, provided he knows that he has the power of disposition over his assets. Okay, can a dumb person who is not able to speak, can he make a will? The answer is yes. They have to only be of sound and disposing state of mind. Okay. Now, I emphasize that care has to be taken to see that when a client comes to you, that you have to gauge and you are easily able to identify and differentiate if a person is of a sound and disposing state of mind. Many a times people will come up and say, my uncle, he's little bit not there, we want to make a will. Now, the duty is upon the legal professional to see that he acts on the instructions of the person who is giving him instructions to make a will and not of any other person. So those cares have to be taken by the legal professional. Now they will ask a will. Do you have any special specifications for a will? A particular paper, a particular ink? Do you require that? So the answer is no. There is no prescribed format to prepare a will, but over the years, there has been a structure of how basically a will is prepared. Because as I told you that the will is right from the times of the Romans, and from the times of Julius Caesar. And Julius Caesar was the first person to give power to his soldiers to make wills by the word of mouth, privileged wills. Okay, that will come a little bit later also. And since there is no prescribed format to prepare a will or no page, you can prepare a will in the way you want it. But as I have said it, a legal professional will help you structure your will so that there is a flow. There is a flow in the will which your executors will be able to understand, which the court will also be able to understand. You see, a will has to be in a clear and an unambiguous way. A will can be prepared in any language which can be understood by the testator, or it can be prepared in a language which is commonly understood, but the contents will have to be explained to the testator. Now, a testator will say, okay, can you prepare a will in Gujarati language or in a French language? So you can prepare in a language which the testator understands, or in a language which commonly the general people would understand. So if a Frenchman is residing in India, basically, who has Parsi antecedents, if he wants to make a will in French, you can make it into English and then explain the contents to him, and then he can do so. Or a Parsi living in a rural area. Why just take a Frenchman? Let's take a Parsi living there are Parsis still living in white northeastern states and all. They do not understand Gujarati or a little smattering of English, but they can understand the local dialect over there. So you can either prepare a language. If they ask you in Bombay to prepare a will, you can prepare a will in English and explain to him in his own language to an interpreter or a translator, and that would be a valid will. Now, can once the testator is satisfied, now that you have prepared and the whole roadmap is there, and you have reduced the will in writing, now what are the legal requirements? So we have understood the aspect of who can make a will. Now let us understand the legal requirements. Because if you had seen in my earlier slides, I have written the word a valid will. So a will has to be valid. Okay. And how do you make a will valid? The will which is valid has to be acceptable by the courts. So once the testator is satisfied that the will is made according to his instruction, he can either sign it himself or he can make a mark. He can either put his thumb impression, or he can put his signet ring on it, or he can put, if he has a family seal, he can put a family seal on it, or this is very, very important, or he can direct some other person to sign in his presence. Okay, so I have underlined it so that my viewers, my listeners can understand that the legal requirement is threefold. It's in the alternative. So you can either sign it of your own, or you can affix a mark. You may say, I don't want to sign, but I am known by my mark. So you can either affix your mark, or if you really cannot sign, or cannot make a mark, or you cannot sign, then you can ask somebody else to sign that will in your presence. So this is also what the court allows. Okay, so I hope that this is very, very clear to my listeners. And now with this we can go on to the next topic, to the next slide. So one of the most, what you can say is, the heart of the will, once it is signed, it needs to be attested by 2 or more witnesses, each of whom has seen the testator sign. It has to be attested by 2 or more witnesses. No, just maybe go to the next one, please. Yeah, stop over there. Thank you. So the will has to be attested. It is known as an attestation clause by 2 or more witnesses. So you can have 2 people or more than 2 people who have seen the testator or the testatrix sign in their presence. Okay, or some third person signing at the direction of the testator. Now, why is the role of an attesting witness very, very important? The role of an attesting witness is very, very important because they are the people who will testify that yes, we have seen Mr. A sign the will, affix his mark, or directed a third person to sign in our presence. And we are there as his witnesses, and we hereby certify that the will has been signed is a proper and a genuine will. Because a dead man cannot come and say that, look, this is my signature. So it has to be corroborated. It has to be attested by 2, not 1. Because suppose the law, it's very clear. Suppose if you have 1 witness, then what happens? Suppose if that witness dies before or predeceased the testator, then what happens? Then the will becomes an invalid will. So that is why 2 or more. So the law in its foresight and in its wisdom has drafted that you require 2 witnesses or more. You can have 3, 4, 5, how many ever, to sign, to attest that a person has signed in their presence. Now, do you require a will in writing, or can there be an oral will? We'll come to that a bit later. But a will has to be, it can be drawn and reduced into writing on any paper. Presently in India, we do not have a provision of having a digitized will. It is there in America, but it is not there over here. So a will necessarily has to be drawn up on a paper. It has to be attested by 2 or more witnesses for it to be a valid will and for it to be met and for its legal requirements to be met. Okay, then the next question is asked, whether a registration of the will, should we get the will registered? So registration of a will is optional. I mean, it is suggested that the registration being done as advised by the legal professional on a case-to-case basis. But registration per se is not mandated by law. It's not compulsory. It is optional. So I hope that there were many questions which were asked prior to the webinar starting about this. So I hope to have addressed this question on registration, whether it is compulsory or whether it is optional. So the answer is it's optional. Okay, now let's go to the next slide, please. Okay, now we have come across the rules which can be made by privileged people or privileged wills, which is a sailor, airman, or a mariner. So there are special rules for them. The people who are unprivileged don't have those special rules. But for Parsis who are in the armed services, who are in the armed forces, or who are even in the merchant navy and who are sailing on the high seas. I mean, a lot of Parsis are in the merchant navy. A lot of, Parsis are all around the world are there, in the armed forces. So they can have special rules or privileged wills. So it can be wholly handwritten. They can write by their hand, and if they write by their hand, it does not require any attestation by 2 or more witnesses. Okay, if it is handwritten wholly or in part by any other person and signed by the sailor, soldier, or the airman, then no attestation is required. Then coming on to the next thing, if a document purports to be a will, purports means suppose it is a will, or so it is supposed to be taken as a will, and is prepared in whole or in part in the handwriting of another, but it is still signed, it can still be treated as a will. Okay, so these are the special rules which I have just encapsulated in a one line so that it is easier for the viewer to grasp. A privileged person may make a will by word of mouth, declaring his intentions before 2 witnesses. So now just see the alternatives which are given by the law. These are all the alternatives, and it is alternatives are only for people who can make privileged wills. So a privileged person can make a will by a word of mouth, what is called as an oral will, declaring his intention before 2 witnesses who have to be present at the same time when such declaration is made. But care has to be taken that if the privileged person is alive after a period of 1 month, then the oral will ceases to have effect. So, there are ifs and buts. So read it at a little leisurely pace, that if a privileged person can make an oral will by word of mouth before 2 witnesses who have to be both present at the same time. So a captain of the ship, for example, if he thinks that the ship is going to collide, and as a captain of the ship, he will go down with his ship, but he will give orders to his first officers and the second officer. He can make a will, he can say to the first officer and the second officer that, look, this is to be given to my wife, this is given to my children. Then he goes down with the ship, So his will is a valid will and it will take effect. But if he survives the shipwreck and 1 month has passed, then his oral will have no effect. Then it ceases. Okay. Now, coming to the next point, if a privileged person has written instructions but died before he could prepare it, so he just writes this on a piece of paper. Just imagine or take a situation where a person has to, go into battle, and just before going into a battle, the soldiers are asked to make one last phone call home or whatever. So we have one soldier over here who has written his instructions, given it to his commanding officer, and goes to fight a battle, and he is martyred. So his written instructions are also considered as a will. So these are the special cases for special people where the law has made an exception. For the rest of the citizenry, you have to follow the rules relating to unprivileged wills. Okay, I hope that this is clear. Now we can go on to the next slide, please. Okay, now there are certain things which has taken place after 2014, 2015. And this is a very new topic, and which is now recently introduced into India. Now in 2018, now this is basically a very, it's a topic which you can say we have to tread, we as legal professionals have to tread very carefully. And also the person who is making a will has to know of it. So this heading is advanced directives.
Manek, jara please, faster, please.
Yeah, sorry. So this, sorry.
Faster.
Okay. So in advanced directives is basically what you call as a living will. Now a living will is what? Living will is a misnomer. Now these are advanced directives in which the constitutional bench of the Honorable Supreme Court of India has stated that if you have a right to live, you do have a right to die also. Now this is basically passive euthanasia. Now I would like the readers to quickly read through it, that the Supreme Court of India has given rights to a person to refuse medical treatments. If a person is in a persistent vegetative state, or he is in a state where he cannot recover from his malady, and this advanced directive, the court says that you can make it during your lifetime, but there are certain safeguards. Now, this topic is by itself a very deep topic, and it will take more than an hour. So kindly have a read through this, and then we can go on to the next slide. The advanced directive, as the name suggests, it is a directive to the doctor and to the executors. It is prevalent in other countries, but it has come a bit late in India. And you can interweave it in your own will, or you can create a separate document to it. But there are special rules for this also. So I'm just drawing the attention of all the people, of all the listeners, that this is a very topic. It's a new topic. There are a lot of impediments which still have to be smoothened out. But yes, you can give an advance directive that you want to, you can die with dignity. Now let's go to the next topic, please. Okay, so who can make these advanced directives are over here. I mean, you have to be of adult and sound mind first to make an advanced directive. So when you're healthy and in the fitness of your mind, state of mind, you can also give this advanced directive. And it will really put the minds of the treating doctors, the caregivers and the families, and a deep thought has to be given by the person making it. Okay. And there are certain safeguards, and your lawyer will be the best person who can guide you. Okay. We can go on to the next slide. Okay, now I will quickly run through this because this again is encapsulated in chapter 4, in chapter 3, part 4 of the Indian Succession Act. So if you die without a will, the headaches and the heartaches which will then follow is written over here, or it's written in a nutshell over here. So when a Parsi, now let us just quickly run over through it. I hope everybody is able to read it fast because we are running short of time and we do not have that luxury. So the law of intestate succession. So when you die without a will, then who all can succeed to your estate? Now the law says that there are several permutations and combinations. So if you have a wife, or if you have a wife and child, or if your parents are living, so all these permutations and combinations of your relationships which are there existing, it can, they will take a part of your estate should you die without a will. Okay, so can we just go up? So if you have a widow and children only, then everybody will get an equal share. So if there is a widow and 2 children, so everybody will get 1/3, 1/3, 1/3. Let's go to the next slide. Okay, so if the parents are also there, then the parent or parents will receive a share equal to half the share of each child. So the parents will also get a child. Now, coming to the next point, in all cases where a Parsi dies leaving any lineal descendant, and such lineal descendants would, lineal descendant dies but has as a wife or a child or a widower or is a widower and have children. So these are the shares in which the son, the widow, and the children would inherit over there. Okay. Now, just quickly read it over through it. So even if a grandchild is there, so even if there is a predeceased, so for example, if I have a son who predeceases me, then his widow and my grandchildren will also be taken care of. Now, if I have a daughter, only her children will be taken care of, not my daughter's husband. Okay. So all these points which are there will have to be. Now, if my grandson expires, predeceases me, so even the law has taken care of that, because in the days of yore, in before 1925, early marriages used to take place, and there were very, very large families. Today we do not see that scenario in the Parsi community. So no need to go over through all these things, but just suffice to say that today we have a wife and a children, they will take equal shares. If there is a parent or parents, they will also be taken care of. If your child or if your child predeceases you, his widow and the grandchildren will also be taken care of. So if now let's go to the next slide. If you are a bachelor or spinster, that also is taken care of, because there are schedules to it as to who will stand, who will take your shares, and these are in part 1 of the schedule 2 and part 2 of the schedule 2. So if you read over here that if you die leaving a widow and also widow or widower of a lineal descendants, then how the shares are given: 1/3, 1/3, and 2/3. So if the Parsi law takes care of each and every relation. Now, let me stress over here that when a Parsi dies intestate and there is no relative, the government will not has no right to eat up the property. Okay, like in Christians, the property will be taken over by the government. But in so far as Parsis are concerned, the relatives, even though how far off the relatives are, they will always get a part of the estate. Okay, so over here, everybody can quickly read through, because I think we are exceeding our time limit. I mean, if you like to have another session, I mean, do write into WZCC, and then we can always have a follow-up session. But as of now, I would just like you all to have a read through over here. Yeah, okay. So if there are no relatives, they are likely to succeed. Sorry, if there are no relatives, then the far off relatives will get. Okay, so let's come to the next step, or to the next slide, please. I think that is the end of the slide. So all in all, I would like to say this, that it is imperative that everybody must make a will. It is imperative that you should go to a legal professional. Don't let any other person cajole you or say you don't have to go to a lawyer, we'll make it for you. Don't do that, because there are types of wills, and a lawyer will help you explain whether you should have a joint will or a mutual will. Sorry, I have not dwelt upon those aspects, because given the time constraints, I could not encapsulate everything. But just taking a few questions over here, just taking a few questions which I have received during when the webinar was announced. Insofar as your uh, co-ownership properties or properties which are held in societies are concerned, there is a new section 154 of the Maharashtra Cooperative Societies Act, which says that you need to get a probate done. A nominee does not stand a chance to be treated as an heir. Okay, so even if you make a nomination, it will only be treated as a temporary thing. And of course the succession will overrule the nomination. So that is one thing. Insofar as your bank accounts are concerned, you have to be very, very specific. What are the operating instructions given, whether it is either or survivor, or is it only singly or survivor, and all those things. So there are very, very various permutations and combinations. I'm sorry, Nawaz, I cannot repeat what I have stated, but I have to go a little bit fast on this. And insofar as you know, tenancy, you cannot bequeath your tenancy come what may. But your lawyer, if he's smart enough, will assist you into seeing that how your tenancy rights can devolve on to the person of your choice. Okay, so with this, I thank everybody, and I also thank my junior, Ms. Jyotika Raichandani, who helped me prepare the PowerPoint presentation, and for the opportunity given to me. And I thank my American audience as well as the UK audience, especially my Indian audience and the WZCC, for giving me an opportunity to share my knowledge. So thank you so very much. Tandurusti to all.
Thank you, Manek. This is Xerxes Master from the WZCC. Thank you very much for a very thought-provoking and a very pertinent topic, especially in today's times. You addressed the core issues very well, and many of the questions, there are a lot of questions in the chat box. Unfortunately, due to paucity of time, we are unable to share it today. But perhaps they can write, WZCC can compile the questions, and maybe you can take it from there if at your leisure. Would that be okay?
Yes, yes. During this pandemic times, I mean, we are all confined to our homes. So yes, I will be very, very happy to assist my Parsi brethren in addressing all their issues. But I will address them in a general way. I cannot be specific. And I hope you all can understand this, because every question is on a, basically we have to know the full merits of the case before we advise. So I will be giving you all general guidelines that can be done.
Thank you. So thank you very much, Manek. See, will making is, as you rightly put it, an inevitable but necessary chapter in our lives, especially in these times. Many procrastinate on the same to a very great extent. Even the great Dhirubhai Ambani, with all his foresight and vision, did not make a will, and then we saw what happened. So on a lighter note, we have to have the will to make a will. If you want your future generation to be in peace and not give you grief from below, you should make it one as soon as possible. I would like to thank you for your very in-depth presentation and for the time taken by you. I would also like to thank Yazdi for providing us his VC platform, repeatedly that he does so. And we hope that above all, thank you to the audience. We have a record audience today of over 140 people. I think that bears testimony to the importance of the subject, and for you as a speaker, I hope that this will help them in making the right decisions at the right time. So on this note, and after such a heavy topic, I think we all need a stiff drink and a nice dinner. So good night. Thank you. Stay safe and take care.
Thank you so much.